Tonight, convicted murderers Erik and Lyle Menendez are rethinking their strategy for release after both were denied parole last week. Two separate parole panels ruled that they should stay behind bars, citing disciplinary violations and questions about their behavior. Their attorney, Mark Geragos, he joins me now live. Thank you so much for being with me. You joined me live and my colleague Phil Schuman exclusively Friday night after this. We got your reaction. We want to talk to you now about next steps moving forward. Let me just start with the fact that they were both denied, and ultimately the parole members, the board members, said they characterized them as having antisocial personality traits. You disagree with that?
Yeah, well, you know, as I said, I think I said to you, maybe somebody else, when you talk about personality traits, everybody since Mother Teresa has died has got antisocial personality traits of some kind. So that isn't really the way I would characterize what the denials were. The denial of Erik was, I thought, markedly different than what happened with Lyle. With Erik, that commissioner, Mr. Barton, came out of the gate and appeared to have his mind made up, focused on the crime itself, and to the extent that Erik, over the last 12 years, has shown a remarkable ability to do really good things with no hope for over a decade, was completely ignored. And the purported cell phone violations bore absolutely no connection to criminality. So that was perplexing. Then when you move over to Lyle, which was the next day, last Friday, that Commissioner Garland later characterized in her hearing with Lyle, the worst day of her professional career. Well, what was she referring to? While they were denying both Erik and Lyle their freedom over cell phone violations, which are rules internal to the prison itself had to admit, because we confronted them after at first they blamed the victims, they admitted they erroneously violated the rules and released the audio tapes. So the height of, or the irony of the hypocrisy of the Department of Corrections is on high alert when it comes to these two. And I think you accurately characterized, we've reassessed in this sense. I plan on going both and putting this directly in the governor's lap and ask him if he feels like this was due process, and ask him to do what constitutionally he can do. And I also plan on taking it to the Superior Court and pointing out what I consider to be the hypocrisy and lack of due process.
Okay, there's so much to unpack there. First, let me just start with the governor. We reached out to the office today, the governor's office, and asked for comment on all of this, and noting how you feel. And we just got back that the applications for clemency are still pending, because the power does lie with Governor Newsom to grant these brothers clemency. We'll see if that actually happens. You are going to appeal.
So, Marla, just take a sec, because there are two roads there, and they're absolutely correct. The clemency, and you might remember, when we first applied, they had dangerousness hearings, okay? And that was kind of they were going to revive
for
that.
The risk assessment.
Exactly. They only converted that to a parole hearing once Judge Jessic resentenced them. So their governor's office is absolutely correct. They do have the power to grant clemency, number one, the governor does. Number two, they've got the ability to reverse what the parole board did on Thursday and Friday. And I think that they should do one or the other. And I'm sorry for interrupting you.
No, well, I asked them that about will they reverse this, and I didn't get a response to that portion of my question. So we will wait to see. Getting back to the rules violation with the contraband cell phones, but critics, Mark, would say that if you're not going to follow rules when you're behind bars, why are you going to follow them when you are free?
Well, remember, the only way that you can use the cell phone violation as a basis to deny parole, there has to be a connection to criminal activity. Just the use of a cell phone is not necessarily a rules violation. Neither hearing, neither one, showed or gave any evidence of what they call a nexus which is just the legal term for a connection to criminal activity. All they were doing, mind you, these are guys who have had their tablet. Everybody's got a tablet, or they get access to a tablet in there. They have had their tablet communications sold and stolen and things of that nature. And by the way, how does anybody think that a cell phone got into the prison? I mean, do you think the drones are coming by and dropping them in?
No, but the parole commissioner, Garland, was saying how this is a form of manipulation, that you use your power, your celebrity status essentially, to garner favor with other inmates and people on the outside.
No, look, you can make that argument about anything. The reality is that cell phones are rampant in the California prison system. When I say rampant, I mean rampant. You can't go a day without cell phones being confiscated throughout the California prisons. How do you think they get in there? And the system allows for it, so to speak, and kind of builds into it. I know that when I have to talk to them, I have to pay in order to talk to them. So all it's doing is protecting the for-profit motives for the people who do business with the prisons.
All right, so we can expect an appeal from your firm as it relates to what we heard last week with the parole commission, the parole board saying you will stay in prison. Okay, Mark Geragos, as always, grateful that you'll take the time out to join me. Thanks so much.
Always good to see you. Thank you.